Hello everyone, my name is Casey Zulita and I will be discussing conspiracy as it relates to Canadian business law. Conspiracy is already a substantial legal concept carrying heavy consequences for businesses, particularly in areas of competition, contracts, and liability. I will discuss the legal principles of conspiracy through a selected Canadian legal case that showcases the said law, and how it relates to our textbook definition. I chose Hunt versus Carey Canada because it shows that simply hiding facts without a single smoking gun document can still satisfy the tort, a warning every risk manager should know. According to our textbook, Managing the Law, the Legal Aspects of Doing Business, conspiracy occurs when two or more parties act in an agreeing manner to cause financial injury to another. This definition is vital because it mentions both the aspect of agreement and the wrongful intent as required to invoke the action of conspiracy in a business enterprise. For clarity, courts now express the doctrines as a four-step test. Number 1, agreement among at least two defendants. 2, intent to injure the plaintiff, either as the predominant purpose or by unlawful means. 3, means that are unlawful in themselves or lawful acts pursued with the injuries or purpose. 4, resulting damage suffered by the plaintiff. The 4-part frame is what the Supreme Court applied in Hunt. The case that I've chosen in reflection to this is Hunt versus Carey Canada. This landmark Canadian decision tackles the procedural difficulties of pleading the tort of conspiracy and the requisite standard of evidence necessary to establish a valid case. It is especially interesting because the alleged unlawful means was a decades-long silence about asbestos danger, a reminder that omissions can be as actionable as overt misconduct. Hunt versus Carey Canada is a case in which George Ernest Hunt, a resident of British Columbia, worked as an electrician in a shipyard until 1967. He alleged that while in employment, he suffered exposure to products containing asbestos, which he believed causes diagnosis of mesothelioma, a rare and aggressive type of cancer. Hunt claimed that several companies engaged in the mining of asbestos and the production of asbestos products knew about the danger of health risks posed by asbestos as early as 1934. Still, he alleged that these companies conspired to keep it from the public and the workers. He sued some defendants for negligence and all defendants, including Carey Canada, for conspiracy to injure by concealing the dangers of asbestos. In Hunt versus Carey Canada, the Supreme Court of Canada had to address a tort of conspiracy in context with the company's alleged scheme to hide the health risk posed by exposure to asbestos. The court examined whether claims by the plaintiff did indeed disclose a reasonable cause of action for conspiracy. The court has acknowledged two forms of the tort of conspiracy. One is predominant purpose conspiracy, where the defendant's primary intent is to injure the plaintiff regardless of whether the means employed are lawful. The second is unlawful means conspiracy. It's where the defendants use unlawful means to achieve their objectives, and the plaintiff suffers damage as a result. It was alleged by the plaintiff that the defendants had knowledge of and concealed the dangers related to asbestos, which injured the plaintiff. According to the judgment, such allegations, if proven, can fit the definition of unlawful means conspiracy because the concealment of hazards to health might very well fall into the category of unlawful behavior causing injury. The Supreme Court went further. Justice LaForest confirmed that prolonged concealment can itself satisfy unlawful means, thereby expanding the scope of the second branch and warning that silence may breach statutory or common law duties. Put differently, the court signaled that prolonged concealment can satisfy the unlawful means branch, allowing the theory to proceed to trial without deciding its ultimate merit. Moreover, the court noted that an action should not be struck out at the pleading stage because it is a new or complicated cause of action unless it is obvious and not disputed that the action cannot succeed. This ensures that plaintiffs are encouraged to put their case fully before the court, especially in cases of serious wrongdoing such as conspiracy. In Hunt versus Carey Canada, the Supreme Court of Canada dealt with the question of whether the plaintiff's conspiracy claim must be struck out because he failed to disclose a reasonable cause of action. The court held that it was not plain and obvious that the claim could not make it, and cautioned that novel claims should not be struck at this point if they involve serious issues to be tried. Hence, the court dismissed the appeal of Carey Canada, allowing the case to proceed to trial on the plaintiff's claim. The decision reiterated the idea that courts should allow the law to develop through full consideration of complex or emerging legal issues. The Supreme Court's ruling did not, in terms of relief, grant immediate remedies to the plaintiff. Instead, it essentially allowed the legal processes to go ahead and enabled the plaintiff to have an opportunity to present evidence and plead the merits of his conspiracy claim in court. Should Hunt ultimately succeed, textbook remedies could include general damages for pain and suffering, special damages for quantifiable losses, and even punitive damages to denounce egregious corporate misconduct. For tomorrow's managers, 3 takeaways stand out. Concealing known hazards may ground a conspiracy claim, not just negligence. Collective silence among competitors can itself be the agreement that creates liability. A culture of transparent risk disclosure is cheaper and safer than betting on secrecy. In essence, conspiracy within the framework of business law deals with exceedingly sophisticated legal doctrines that substantially affect businesses joining coordinated illegal activities. Remember, agreement plus intent plus unlawful means or purpose plus damage equals conspiracy. Hunt versus Carey Canada is a great demonstration of how courts assess and apply these principles to business disputes and thus guides the development of the law in such areas. Thank you so much for your time. To wrap up, I look forward to your discussions on the board. Thank you.